see you, brother. Thank you.
Please identify yourselves, and whoever wants to go first, go for it.
You want to go? Okay. Good afternoon, everybody. My name is Chris Alexander, and I represent the Alexander Citizens Advocacy Group, which includes my wife, Katie, who was here earlier, and I also represent citizens across the state who I've spoken to regarding 221 that I had a hand in helping to get done, and people who are just very concerned about election reform in the state. A lot of what I wanted to say has been covered. The primary point that I want to bring up again, and I would encourage everyone here to read the opinion, it's the Raffensperger opinion, and it's a federal court opinion out of Georgia that engages in a comprehensive and very readable analysis of the difference between secure hand-marked paper ballots and ballot marking devices. And the crux of the matter is the experts, such as I think Mr. Haldeman, Alex Haldeman, he may have actually testified here. He was one of a number of cybersecurity experts, including Andrew Apple, Harry Hursty, Vincent Laveau, Kevin Strachan, world-renowned cybersecurity experts who said, basically, and I encourage y'all to read this opinion, that there isn't a ballot marking device system anywhere in the world that is not subject to intrusion. That is not subject to hacking. That is not subject to manipulation. It doesn't exist. And Representative Ivey, I'll tell you now, I'm not a cybersecurity expert, but I've read this 45-page decision, and it was very compelling and very convincing to a sitting federal judge in Georgia who granted the plaintiff's preliminary injunction based upon her finding that virtually every ballot marking device in the world is potentially vulnerable to hacking by cybersecurity by guys who want to hack into our system. They can do it. Any machine-based system, any system connected to a machine is subject to hacking. I will provide this decision to you and allow you to read it. But the suggestion that there is no fundamental difference between the security level that we would enjoy with a secure hand-marked paper ballot system and one that involves a ballot marking device is simply not credible based upon the best experts in the world. Mr. Lunsford, I believe, indicated earlier that Mr. Haldeman basically testified to that at the last hearing. I wasn't here for all that. I was here for part of it. But I'm just going by, like my cardiologist tells me, hey, you got a problem with your heart, you need surgery. I don't need to know what the inner workings of the heart are to know he's right, I'm relying on him, and we're gonna have heart surgery here. So I can't explain all the intricate details of it, but I'm telling you what these experts are saying. I also wanted to indicate reiterate what Lennar said earlier. 75% of the country right now is using a secure hand-marked paper ballot system, and that is verified by Judge Totenberg in the ruling. And the only times that ballot marking devices are even used in other states now in the voting system is upon specific request of a voter in case of a disability, or if a voter just wants to use a ballot marking device, they can do that. As far as the logistical hurdles that have to be overcome, the staffing, the manpower, with the amount of money that this state spends every year, and at times even squanders, we can afford to invest whatever resources we need to in order to ensure that the heartbeat of democracy is maintained at all its integrity. And if the experts are saying that a secure hand-marked paper ballot is the only foolproof way to ensure that will occur, then we need to do what's necessary to make it happen, whatever staffing issues we have or fiscal issues may exist. I wanted to point out also, there was a representative earlier from the EAC, and I don't know if he's still here or not, but I know because I've read this, and this is also cited in the federal court opinion, The seminal report from the EAC Board of Advisors in 2018, and this is a direct quote from the Board of Advisors from the Election Assistance Commission. They recommend against the I know we're seeking certification for the EAC, Secretary Erdogan, we're required to by law. And the EAC specifically said their own Board of Advisors recommended against certifying any system that does not use a voter verifiable, reader identifiable paper as the official record of voter intent. The official record. Not optional, not something that you're just kind of comparing against a ballot marking device. The EAC has recommended against certification of any system that does not use a voter verifiable, identifiable paper as the official record of voter intent. That's the EAC. So I would not want to be in a situation where this commission makes a recommendation and we're trying to get certification from the VAC and perhaps we don't get certified because the primary method of voter intent of record is not paper. One or two other points I want to make here. Senator Hewitt, I wanted to remind you, if I could, about an open a part of the contents of an open letter that you wrote back in June of 2021 when we were working together to try to get this legislation passed. And I agree with what you said then, and I'm assuming that you still believe this, because I certainly do, and I agreed with you then, I agree with you now. But you indicated that this bill, 221, eliminates from consideration all electronic voting systems, which is what we currently use because we haven't passed anything yet for our elections, and which Secretary Erdogan at the time was trying to pursue in a bid request at that time. But you indicated the bill eliminates from consideration all electronic voting systems, and rather instead your legislation requires that a paper-based voting system only be considered, which could be hand-marked or machine-marked paper ballots, and you reiterated that a few minutes ago, that certainly a secure hand-marked paper ballot is an option. My primary point here is to tell you that based upon what I've seen about the experts and what I believe Mr. Halderman testified to before, there is a fundamental distinction and a significant difference in the level of security provided by a secure hand-marked paper ballot and that which is provided by a ballot marking device, according to what the experts have said in Raffensperger and according to what Mr. Haldeman, I believe, said basically here. Again, I'm not a cybersecurity expert, but we need secure hand-marked paper ballots in the state of Louisiana because it's the only system that is basically not vulnerable to hacking. Thank you.
Representative Ivey.
Thank you. I will be brief, Mr. Secretary. So for clarification, Mr. Alexander, the Georgia federal ruling, the judge determined that the hand-marked paper ballot is the most secure method of voting. The judge determined that, or was there?
The judge,
I need you to speak into the mic. Thank you.
The experts testified, and actually, Representative Ivey, they actually were able to, as part of the case, these experts were seeing if they could hack into the BLM system, the ballot marking device system where they had set up in Georgia, which is a HQ code, non-encrypted code, right?
Okay, I don't know. So I will read the case because I'm interested. But
I want you to read the case.
So, but some of the statements you made, I need clarification for my purposes. So, you stated that, again, not verbatim, but something to the effect that it was determined, the judge determined that, the safest method in the world.
The judge agreed with the experts who testified that a system based upon a ballot marking device is subject to intrusion based upon malware,
Well, it would depend, obviously, and so I don't think anything could be conclusive, just, that's a very general statement that it's absolutely conclusive. So I would,
Yes.
that's a difficult statement for me to accept.
Well,
But
the court in noting and agreeing with all of these experts that the ballot marking device system as set up in Georgia was vulnerable.
how was it
subject to
vulnerable? Why
intrusion.
was it vulnerable? Was it connected to the internet?
Yes. Well, I don't know exactly if it was connected to the internet or not.
Right, and so
They were-
again, some of these things are what creates the vulnerability.
One of the there was one of the experts, actually two of the experts, who said that whether or not it is connected to the internet, it still can be remotely made vulnerable. It can be intruded upon. I think it was. I can get the names of the two
If there
experts who said
is
that.
hardware that allows for wireless connectivity, then yes, it might be possible. But if there's no hardware that allows for wireless connectivity, no Bluetooth, no Wi-Fi, right? There's only an Ethernet cable, right, or a USB port where some drive or something has to be connected. Then again, so there's different setups. So I don't want to use
there are-
Georgia's failure or issues
no.
as the standard to determine the direction for Louisiana.
I'm not saying that. What I'm telling you is that the court made a point to note approvingly that the majority of jurisdictions in the United States use human readable, secure hand-marked paper ballots as the primary method of voting.
Okay, so it said specifically human readable.
It said
Hand-marked?
hand-marked
Can
paper ballot.
I intervene here?
Yeah.
Is this the case that was filed in 2017 by citizens in Georgia?
Yes, it's 2018 draft. I have the site on it if you
Yeah,
want.
because this case is not even close to being finished. We just dealt with this. We just filed an intervention. The judge denied us intervention, but then gave us the ability to deal with to contract with Mr. Halderman to bring him in to see what those vulnerabilities are. The court is still holding the Halderman report in, what's that called? Eyes only for the attorneys, but she's got it under seal. Under
Sure.
seal.
I was able to read the ruling. It's a 45 or 50-page ruling in which Judge Totenberg affirms the findings of these experts that talk about the vulnerabilities in a system involving a ballot marking device.
Right, but she's keeping the report under seal until the final outcome or whatever the outcome is of the trial, correct?
Well, I mean, I was able to read the ruling. I have the ruling is a matter of public record, and I have the site on it.
Sure.
I'm just saying, I think we need to be careful, Representative Ivey. We need to be careful when we start, and I'm not saying there can't be some form of a hybrid system. Perhaps that is the most efficient way to go. What I'm saying is, I think we need to be careful if we start equating garden variety ballot marking device with a secure hand mark readable paper ballot that a voter can look at and identify as his ballot and his choice.
Right, and so I think we're on 100% agreement that I believe every voter should have a hard copy paper ballot that is the official ballot, where they personally can go put it in a scanner for tabulation or whatever. And the only difference, I think, is whether or not we should allow, create an electronic ballot marking device, system versus hand with pencils. And you mentioned the most secure, it's written with a number 2 pencil. So you can erase things. I mean, it just kind of, I can't, anyway. So I think we agree what the end result needs to be. But I mean, anyway.
I would encourage you to read this decision.
I will.
Because you were not making any specific, when you were talking about a ballot marking device earlier and
I
comparing
know
it
I was
to-
being very generic.
You were, and very, and
electronic
and extremely
ballot
general,
marking
and extremely general. So if you're going to be general and just talk about ballot marking devices in general, well, I'm telling you as a matter of general principle.
I would agree
a
if I
hand-marked
was being
secure-
too general.
Yeah,
I
a
did not
hand-marked
disagree.
secure
Yep.
paper ballot, handwritten and readable by a voter, is more secure than a ballot marking device. And the court basically held that based upon the testimony of a lot of experts. So
All right, well, I'll go through it, but anyway, I'm gonna leave it at that.
Mr. Clerk,
If I may jump in real quick, I've got the case. It's Curling versus Raffensperger. It's actually 147 pages long.
I must have fell asleep
I've
after
already
63.
emailed it to John McGee, so he's got it and he can share it with the board. And I haven't studied in the detail that I need to, but it's got a lot of summary of the problems and the issues, some of which I think are particular to Georgia and the system they were using, but nevertheless, I think it's helpful to us to at least know what some of the issues out there. So I've sent that to John McGee already, and he can share it with the rest of the group.
The last point I want to make, and thank you for that, Mr. Cleary, just a reminder of what everyone already knows, that what 221 requires, which it requires an auditable voter verified paper record. No voting system equipment can connect to the internet. Representative Ivey, and I think that you were instrumental in ensuring that.
I think, Mr. Alexander, if, I know that you weren't here at the very beginning of the meeting, but Ms. Landry captured all of that
Okay.
and read it to the
Fair enough.
commission.
We know what
So
the requirements of the bill are, and
we
thank
appre-
y'all very much.
Thank you. And I understand your spouse, Ms. Katie, she had to leave.
Yes, but she doesn't necessarily incorporate by reference any of my comments.
Okay. All right.
She asked me to say that.
She's part of your association.
Well, she is.
You already stated
She's a
that.
very grudging member.
She's the president of your organization, correct? John,
Yes, she is.
I'm going to go. Okay, John.
All righty. How y'all doing? Again, good to see you all. I'm John Scanlon. And for those